Hey everyone, Judicial Watch President Tom Fitton here with our weekly update on social media. Thank you as always for joining us. A lot going on. It looks like Jack Smith and the Biden Justice Department are unhappy with yours truly and Judicial Watch. I'll talk about that. More updates on the continued abuse of President Trump up in New York and elsewhere. Of course, that's all tied up with the targeting of Judicial Watch by the Biden Justice Department and the attacks on our work. So a lot to talk about there. We have a major new legal development in our case for Ashli Babbitt's family, that $30 million wrongful death lawsuit. Major new lawsuit for communications about Tucker Carlson. I'll talk about that. And we had a hearing this week on a case for a teacher who was fired because she was posting conservative social media posts. Completely another abuse of the First Amendment rights of another American conservative, in this case a teacher. So a lot going on. First up is the pending criminal trial of President Trump. President Trump is facing a criminal trial on what are fanciful charges in New York City by the Soros-backed prosecutor Alvin Bragg. He is accused of misdemeanor crimes of falsifying records about a payment, a confidentiality agreement payment that he allegedly made. And what they're trying to do in New York is to bootstrap those misdemeanors to felony charges, that the supposedly misdemeanors become felonies or felonies are added on because there's somehow that the way that payment was listed was also a violation of federal election law. Now, if you're wondering why it is a New York City prosecutor thinks he can enforce federal election law and try to jail an incoming president, or not incoming president, major presidential candidate and former president based on that alone, you'd be right to wonder that. And unfortunately, the judiciary up in New York is politicized and anti-Trump and isn't willing to defend his civil rights and curtail this prosecutorial abuse. Now, Judge Merchan, who is the judge in this case, he's been really just generally anti-Trump. In New York, the judges are appointed through the Democratic Party, more or less, certainly in New York City. That's how it works. They're elected, but essentially they need the approval of the Democratic Party to even be on the ticket or to be considered by voters. And once they're put on the ticket, they get the judgeship typically. And in the case of Judge Merchan, there's this additional issue of his adult daughter having been involved as a campaign or some type of, I guess, policy consultant, to put it charitably, but she's working with campaigns as well. And according to news reports, she was making a boatload of money, or her campaign or her firm was, working with political opponents of Trump and specifically doing fundraising based on the fact that he's being prosecuted in her father's court. Conflict of interest. Dem client's a daughter of New York judge in Trump hush money trial raised $93 million off the case. Now, the problem for Judge Merchan is Trump lawyer, and as I say here, Trump's lawyers lay out a powerful case for Judge Merchan to recuse himself from handling the Soros-backed Democratic politician Alvin Bragg's abusive prosecution of Trump over that alleged confidentiality agreement payment. The whole issue further highlights, and this is the outrage, that the gag order prohibiting Trump from now mentioning his daughter is so outrageous, because the judge is constraining a candidate running for president by restricting his defending himself from what looks to be a failure to recuse himself improperly, the judge, and related conduct by his daughter, an adult daughter. I mean, it's not like she's a 10-year-old. We're talking an adult who's probably in her late 20s or early 30s. I forget the exact age. But a political operative. So this is a matter not only of a judicial matter, right? He's asking for his recusal, but it's a political matter. It highlights the political nature of the way the process up in New York has been running. And he has every right under law and under the First Amendment, in my view, to defend himself and talk forthrightly about this. Now, the left, of course, is mischaracterizing it, his comments, knowingly, and Trump's concerns is threatening the judge, as if criticizing a judge or anyone associated with the judge, and in this case, properly so, his daughter, translates into a threat. Well, that can't be the case under the First Amendment. You're allowed to criticize figures like this under our Constitution. But of course, it's new rules, different rules for President Trump, and it's really outrageous. And as of now, Trump will go on trial April 15th. And he's likely to be convicted. It's a New York jury. I mean, it's rigged in many respects. So it's a bad day. We're facing bad days for the rule of law, our Republican form of government. And again, as I've said repeatedly, you know, I know people are concerned about the election, right? And, you know, what happened in 2020 will happen again, and fights about when votes are counted and things like that. I think we have to take a step back even from that. Our elections have already been compromised by this abuse of Trump. The 2024 election has already been compromised because the president has been abused time and time again. His attention and resources, as we now know in New York, in nearly $200 million for 2 cases alone, just to appeal those cases. So those are resources that could otherwise be deployed for his candidacy. And obviously his time and attention is focused on these threats to his freedom and his livelihood. And that's election rigging. So the election's already been compromised. And the other big fight is going on in Miami this week, and this is where, you know, Judicial Watch comes in. We, as you know, have the Miami case is the case being pursued by Jack Smith before Judge Aileen Cannon. And Jack Smith is trying to throw Trump in jail on what are violations of the handling of classified records or records covered by the Espionage Act. And of course, the defense by Trump is under the Presidential Records Act, under the Constitution, prior Justice Department policy and such. This prosecution has no foundation. He didn't do anything wrong. And what's interesting is the big fight is that the Justice Department and Jack Smith are very upset that Judge Aileen Cannon is giving Trump the time of day and treating him fairly and taking his constitutional arguments seriously. And so they're going crazy and trying to intimidate the judge, quite apparently, and I'll get to that later. I mean, look at all the left attacks on Judge Cannon, the same left that attacks President Trump for criticizing Judge Engoron and Judge Merchant and Judge Chutkan. It depends who's where, you know, it depends whose ox is being gored, right? And so in this case, which centers around the Presidential Records Act, a big fight is the precedent set by a District of Columbia case pursued by Judicial Watch, the Clinton sock drawer case. And, you know, without getting into the weeds of what's going on in the specific case in Miami, essentially there's a big fight over whether, certain jury instructions that were asked for by Judge Cannon, because she wanted to get a feel for where the parties were in the matter, how they might read as it relates to the Presidential Records Act. And of course, the left went crazy because that seemed to suggest that Judge Cannon was willing to at least let a jury decide if the Presidential Records Act exonerated and vindicated President Trump. And so in response to that, Judge Jack Smith's legal team, Justice Department attorneys working for you and me, the federal taxpayer, went ballistic and filed an hysterical brief that focuses its attacks on Judicial Watch and me. And it begins, this is a section, the notion that Trump might have designated the documents as personal was first invented in February 2022. So we'll get to those tweets later. Put that down for now. On February 7th, 2022, the Washington Post reported that in January, NARA, the National Archives, had retrieved 15 boxes of documents and other items from former President Donald Trump's Mar-a-Lago residence because the material should have been turned over to the agency when he left the White House. That article quoted a statement by the archivist noting, the Presidential Records Act is critical to our democracy, in which the government is held accountable to the people. I don't know what that means. That's just hyperbole. At that point, the public reporting related only to Trump's non-compliance with the PRA, the Presidential Records Act. The fact that he retained highly classified materials did not become public for several days. This is where he brings us in. On February 8th, 2022, the day after the Washington Post article was published, the president of Judicial Watch posted the following two statements on Twitter. And there's all my tweets. So my tweets are now part of the record. It's easier for me to read the screen than my fact check. The left media is being dishonest about the Trump records issue. A president has discretion on what documents to retain as presidential records while in office, so the law allows Trump to tear up documents, shred them, and take documents when he left the White House. And I think the stories at the time talked about him tearing, they were going crazy because he supposedly, or he was alleged to have torn documents up and put them in the toilet. Fun story. Judicial Watch sued over Bill Clinton's hiding records in his sock drawer. And I've told you about that case before. Court told us to pound sand because presidents essentially can do whatever they want with their records. Remember this when you hear anti-Trump media caterwauling about his tearing up documents. Those are two pretty good tweets, I think. And have held up well, don't you think? They've held up well over time. Immediately after posting the second tweet, the Judicial Watch president sent to an employee in Trump's post-presidency office a link to the tweet and offered to discuss the issue with Trump. A few hours later, the Judicial Watch president sent the same person his analysis of the case Judicial Watch versus NARA, which is the sock drawer case. That evening, the Judicial Watch president circulated to the employee a proposed public statement for Trump's consideration, which included language that the PRA, the Presidential Records Act, and judicial decisions gave Trump the right to keep the documents he returned to the National Archives. The statement never issued. And then furthermore, around the same time, the Judicial Watch president, who was not an attorney, I mean, this is like an MSNBC Rachel Maddow opening, right? Maddow, excuse me. Told another Trump employee that Trump was being given bad advice and that the records Trump possessed at Mar-a-Lago should have been characterized as personal. The second employee advised the Judicial Watch president that they disagreed with the Judicial Watch president's analysis. In Judicial Watch, referencing the sock drawer case, former President Clinton had made the designation of certain records personal while president, whereas Trump had not done so. The second employee further informed Trump that the Judicial Watch president was wrong and explained why. Nevertheless, on February 10th, 2022, Trump released a statement claiming, in part, "I've been told I was under no obligation to give the material based on various legal rulings that had been made over the years." Before this time, the second employee had never heard this theory from Trump. No other witnesses recalled Trump espousing the theory until after the Judicial Watch president conveyed it to him in February of 2022. Well, there you have it. Now, I can't talk directly about what's in this, in the sense I can't respond to the specifics on the advice of counsel. But I can say generally what I've been saying publicly, right? And I can say this sort of hysterical, crazed depiction tells you why Smith hates me and hates Judicial Watch, hates our guts, as we say in the title here, and why I was harassed by Smith and the Biden Justice Department with a grand jury subpoena and being forced to testify before a grand jury, and while Judicial Watch was harassed with a grand jury subpoena as well that required documents be turned over. Because Judicial Watch, aside from anything I may have said to the president or anyone else at Mar-a-Lago, this is our public position, as you saw in those tweets. What they were doing to Trump was a sham. Under prior precedent, the Clinton sock drawer case, argued by the same Justice Department, they said and the left-wing jurist up here, left-wing court, found in favor of the Justice Department and archives that no one could second-guess the president's decisions as to which were presidential records and which were personal. And that if he had records, including classified records, after he left office from his days in the White House, they were presumptively personal. And that's why they're harassing us. That's why they're abusing us. Because we blew the whistle based on these public reports, and I've been public ever since, that they did a 180 to target Trump. And that was confirmed further by Special Counsel Hur, H-U-R, who, when faced with the same exact circumstances for Biden, in the sense that Biden had records knowingly and willfully he had no right to, gave Biden a pass because Biden argued, in part, that he had every right to the records. And Hur concluded that was a plausible defense. And compare and contrast that with the hysterics in these documents. As I told you about my prior grand jury appearance before Jack Smith, they argued with me about tweets. They argued with me about what I had for lunch. And they argued with me about this very issue. And I told them about the Clinton sock drawer case. So they knew. They knew. And they tried to intimidate and harass me in a way to undermine what could be the defense that curtails and shuts down that abuse, at least that part of the abuse that's broader, I know, in Miami. Because part of this scandal of Jack Smith is him trying to intimidate the judge into issuing orders about jury instructions and things way before they're due under the law. And the judge says no. I mean, President Trump had been asking her to dismiss this case outright even before the trial began based on the Presidential Records Act. And she decided yesterday, I don't know, do I have that decision here? Yeah, I do. That no, we're not going to decide it now. I mean, I can't dismiss it now because the case needs to proceed a bit before I dismiss it or potentially consider dismissing it based on the Presidential Records Act. So it's still a possibility that this case ends because of that Presidential Records Act. So that's why they spent a page or two yelling about Tom Fitton and what he said about the Presidential Records Act. And of course, you know, this to me is a signal that I've completely broken the Justice Department and Jack Smith. They don't know what to do with what we've said. Our truth-telling has broken them. And the media, of course, went crazy as well. I had this tweet earlier. the Daily Beast, which is like a really nasty left-wing publication, but it's indicative of the way the media and the left has been reacting to Smith's histrionic brief. What did I say? What was the? Do you have the tweet? I have seen how simultaneously broken the Biden Justice Department, Jack Smith, and the left media and their left media minions. This is a quote from the Daily Beast. That theory, which is the Presidential Records Act theory, of course, I'm talking about a decision by a federal court. It's not me. Started with Tom Fitton, the muscle-bound activist who isn't a lawyer but successfully takes on high-profile legal fights through his nonprofit Judicial Watch. Well, at least they said I'm successfully taking on legal fights, right? Again, you know, the weird focus on my personal appearance, the weird focus by Jack Smith that I'm, quote, not an attorney. You don't have to be an attorney to recognize what a case is about. And I can tell you, as president of Judicial Watch, you know, my colleagues, lawyers and non-lawyers alike, have had more significant public and, well, specifically presidential records expertise and background and related work than virtually anyone talking about it today. I mean, it's not just the Clinton Sockdor case. We were in battles with the Clinton administration, the Bush administration, this administration, on federal records issue after federal records issue, including records related to the President of the United States. And the left's media reaction? He's not an attorney. His muscles are too big. It's like dealing with 12-year-olds, right? So I don't know what's going to happen with this case, how it's going to proceed. I can tell you the way I think it ought to proceed. I think it ought to be dismissed. The President of the United States, according to prior Justice Department positions, but not only with Clinton, but with Reagan, because Reagan had material that was classified in his diaries. This was in the Her report. And no one thought to go bother him for it, even though everyone knew he had that material. So this is the first time that the law has been applied this way, which of course is a defense, right? Because you're relying on the way the law has been applied before in decision making. And what they're having to grapple with is that when it came to Bill Clinton, they said no one had a right to second guess the president's decision making on this. And then they say, even if under the Espionage Act, which is a different law, the Espionage Act is a much older law than the Presidential Records Act. I would say the Presidential Records Act probably guides the understanding of how the Espionage Act applies, if at all, to the president. But that's handling of national defense information. He's national defense information. He's commander-in-chief. Trump was. Of course, he has discretion as to what records he keeps as presidential and personal, even if they are technically covered by the Espionage Act. It doesn't override the Constitution or his rights as President of the United States and Commander-in-Chief. They cited Obama executive order as guiding what Trump is supposed to do. In what theory of the universe would a prior executive order by another president restrict the constitutional powers of a subsequent president? So that's the reason they're yelling so much about me and Judicial Watch. That's the reason they're yelling so much and yelling about what Judge Cannon is doing, because Judge Cannon seems to understand this. And I don't know how she's going to rule ultimately. She may decide, let the jury decide. Or, you know, this isn't a defense and, you know, this will all have to be decided on appeal whenever that happens. I don't know. But the idea that the rule of law may work for Trump's benefit is driving the left crazy. And they're upset with Judicial Watch for our truth-telling. And it tells you how important and effective our voices can be. Because you think nothing, I should say this, you think. I know it's sometimes you see these issues and you say, well, what can be done? All this abuse is happening. We can't do anything. Well, we can do something. The reason the Justice Department's attacking me, the reason they harassed me at home with an FBI visit, with a grand jury subpoena, the reason they harassed Judicial Watch with a document subpoena and forced me to go to a grand jury for hours of testimony, was because we threatened their charade of a case against Trump. And it's confirmed again this week by the court in Florida that this is a live issue still. And you can see it's confirmed again this week because they spent pages in a major court filing attacking us. But we're not going to give up. We still got questions for Jack Smith. Who's working with you, Mr. Smith? Why are you hiding the top names of the people working for you? The top staff? What you hiding from us? We have a right to these names under law. We got a federal court case that's proceeding against them now. So we're not intimidated. And frankly, briefs like this are a sign of weakness and panic, not the other way around. Isn't this interesting though, huh? I think it was filed, when was this filed? Was it late Friday night or Monday? I think it was Monday. Oh, here's the date. Well, maybe the date isn't there. Anyway, it was filed at the last minute, and I noticed online folks started talking about Tom Fitton in the brief. I'm like, oh boy, what's going on there? And I can only shake my head, right? I can only shake my head when I see the government yell about my tweets. The Justice Department yelling about my tweets, calling them out on their hypocrisy and abuse of power, targeting Trump. And so, keep on promoting my tweets, Mr. Smith. Please do. Oh, before I get to the next story, I don't want to let this slide, because we talked last week about how the Biden administration's Health and Human Services Agency was flying that crazy transgender extremist flag at their headquarters, which is right near our offices. And I haven't checked to see if other agencies were flying the flag as well. And we talked about that with you last week, you may recall. And then afterwards, it came out that President Biden issued an official proclamation designating Easter Sunday as, here it is, now therefore, I, Joseph Biden Jr., President of the United States of America, by virtue of the authority vested in me by the Constitution and laws of the United States, do hereby proclaim March 31st, 2024 as Transgender Day of Visibility. I call upon all Americans to join us in lifting up the lives and voices of transgender people throughout our nation and to work toward eliminating violence and discrimination based on gender identity. Guess what March 31st was? Easter. Easter. And who do they say, who's at fault for misinterpreting that? Of course we are, right? Because everyone should know the Transgender Visibility Day is March 31st every day of the year, as opposed to it's a made up designation. And rather than recognize that it's Easter Sunday, they proceeded to push it and then issue further promotions of this extremist agenda on Easter. And then Biden was questioned about it, and he made it seem like he didn't know what. Well, like he was Joe Biden. I had a fun video we posted on Instagram about the questioning of him.
Mr. President, what does Easter mean to you, sir? Sir, what does Easter mean to you?
Time for forgiveness and people getting together and working with love and no phoniness. Be straight with people.
And Mr. Speaker Johnson the other day said Speaker Johnson said you betrayed the tenet of Easter by proclaiming Easter Sunday as Transgender Day. He called that outrageous and abhorrent. What do you say to Speaker Johnson?
He's thoroughly uninformed.
Uninformed how?
I didn't do that.
I didn't do that. I just read you what he did. He attacked Christians and all of Western civilization on Easter. I mean, his explanation of Easter, I'll leave that to you to decide whether that sounded normal to you or not. I mean, so what, did he do it or not? Or did someone else do it and sign for him and tell him after the fact? That's what it seems like to me. But it just highlights the radical nature of this administration. And I'm not going to forget, this is what is often frustrating to me, is that you have these wild abuses, right? And scandals. And the media has zero interest in doing anything. You know, they will notice it and then move on as quickly as they possibly can. So we're supposed to forget that the President of the United States and his White House issued a proclamation that effectively attacked Christians on Easter. Mocked their holiday by emphasizing this Transgender Visibility Day. Well, I'm not going to forget it. And certainly Judicial Watch will continue our litigation related to this extremism. As I talked about last week, the HHS has been promoting males chest feeding, the part of this transgender extremist agenda. They want males to be able to pretend to breastfeed infants. Of course, that's not the way it works, right? I mean, just think of the abuse of infants that entails. That's how crazed this is. So we're not going to stop. But it's not getting better, folks. It's not a fun issue to talk about, but it's not getting better, and we have to confront it. So, the other big news is our Ashli Babbitt lawsuit. We filed a lawsuit, a $30 million wrongful death lawsuit against the United States government on behalf of Ashli Babbitt's family, her estate specifically, and her widower, Aaron Babbitt. And that lawsuit was filed earlier this year. And the first reaction, practically speaking, of the Department of Justice, which has to defend this lawsuit, was to move it out of the court in which we filed it in San Diego, where Ashli and her husband lived, and they wanted to move it to Washington, D.C. Why do you think they wanted to move it to Washington? Why do you think they wanted to move it to Washington, D.C.? Why do you think the Biden Justice Department wants the Ashli Babbitt litigation related to her wrongful death to be heard by courts in Washington, D.C.? I'll give you a second to shout your answer. You're right. It's because they think they have more friendly judges here who are anti-Trump and biased against Ashli and anyone else involved in January 6th. We asked the federal court to deny the U.S. government's request to transfer the wrongful death lawsuit, as I say, from California to Washington, D.C., as it would prejudice the case and be unjust for Ashli's family if it were transferred. We filed the lawsuit on January 5th, the day before January 6th, earlier this year, in the U.S. District Court for the Southern District of California on behalf of Ashli, who is an Air Force veteran, remember that, who was shot and killed inside the U.S. Capitol by then Capitol Police Lieutenant Michael Byrd on January 6, 2021. Ashli is the only homicide victim that day. Okay, officially, she's the only homicide victim. Needlessly shot and killed by Lieutenant Byrd. She was a 35-year-old resident of San Diego, young woman, 35, just shot down, where she owned and operated a successful pool business with her husband, Aaron, She traveled to from San Diego to D.C. to attend the Women for America First, the Save America rally on January 6th at the Ellipse. And I want to talk to you about the shooting again. The shooting occurred in the east entrance of the Speaker's lobby. After demonstrators filled the hallway outside the lobby, two individuals in the crowded, tightly packed hallway struck and dislodged the glass panels in the lobby doors and the right door side light. Lieutenant Byrd, who was a United States Capitol Police commander and was the incident commander for the House on January 6, 2021, shot Ashli on sight as she raised herself up into the opening of the right door side light. Byrd later confessed he shot Ashli before seeing her hands or assessing her intentions or even identifying her as female. Ashli was unarmed. Her hands were up in the air, empty, and in plain view of Lieutenant Byrd and other officers in the lobby. The facts speak truth. Ashli was ambushed when she was shot by Lieutenant Byrd. Multiple witnesses at the scene yelled, "You just murdered her." And of course, Lieutenant Byrd was never charged or otherwise punished or disciplined for Ashli's homicide. And so later, I think it was in March of this month, we filed an opposition to the Biden Justice Department's request to transfer venue of the case to the United States District Court here in D.C. Arguing against the change of venue, Judicial Watch pointed out that under federal law, a civil action against the United States may be brought in any judicial district in which the plaintiff resides. And a civil action on a tort claim against the United States may be prosecuted in a judicial district where the plaintiff resides. So we had every right to bring this claim in the Southern District of California. And it's really extraordinary and abusive that we're having to fight right now, this Justice Department, to keep it there. But we cut right to the chase in their brief. Defendant's position to transfer venue illustrates and underscores the prejudice and injustice that plaintiffs would face if venue were transferred to the District of Columbia. Defendant mentions 80 Capitol police officers and 60 Metropolitan police officers that were injured and connects the deaths of 3 officers to the events on that day, thus connecting Babbitt to these deaths and other injuries as if she caused them. The request for a change of venue is clearly influenced by the defendants meaning the U.S. government, the Biden gang, strongest motivation for changing venue, which is to select the forum where it feels it will receive a favorable process and outcome based on adversity against January 6 defendants. By its motion, defendant hopes to unfairly and unjustly connect Ashli to violence, injuries, and deaths for which she is blameless and connect her by association to thousands of individuals convicted of misdemeanors and felonies for which she was never charged and is unable to present a defense due to the lawless actions of one of the defendant's employees in shooting and killing her. That's right. We're reminding the court that Ashli's dead and can't defend herself against the smears by implication of the Biden administration. It's no secret that the District of Columbia is a hostile forum for January 6 defendants. It is also prejudicially biased against Ashli Babbitt. For example, during a recent sentencing hearing in the District of Columbia, United States versus Daniel Goodwin, District Judge Reggie B. Walton made the following statements to the defendant and his counsel regarding the shooting of Babbitt. So Judge Walton is a senior judge. I don't think he's literally senior. He may be. Here in the District of Columbia. He's been on the bench for years. The court said this, and this is what we say. We quote, "You should not have been. You cannot convince me that somehow what she was doing was somehow justified and the police did not have a justification for taking the actions that they took. You can't convince me of that." Judge Walton's statement evidences he has already predetermined a crucial issue in this case, whether Ashli Babbitt's killing was justified. Judge Walton made other biased comments on the record, including, well, she shouldn't have been coming through the window. and this man who was protecting the Capitol ends up being called a thug, that's just mind-boggling. Unfortunately, Judge Walton is speaking what many others are at least thinking behind the bench in the District of Columbia. This court is the only venue, meaning the court in the District of Southern California, which offers plaintiffs a chance of receiving a fair trial. I'm angry. We filed this big case for Ashli Babbitt, her family, and the first thing the Justice Department does is try to get it moved here so they can get an anti-Trump judge, an anti-January 6er judge. Try to rig it, forum shop, judge shop, whatever you want to call it. Let's be blunt. The Biden Justice Department wants to move the Ashli Babbitt wrongful death lawsuit to D.C. because it knows the courts here are notoriously hostile to anyone tied to the January 6th protests. So that's where it stands. The judge has the documents, all the briefs. The case or the issue has been fully briefed. I expect the court will rule soon. And by soon, I don't know what soon means. I would say within a month. But who knows? I don't know. So this is the sort of work Judicial Watch does. We file the lawsuit, but of course, you hear that, right? But then that's only the beginning of the work. And so we're facing this major battle against the Biden Justice Department as they try to move this case from California to here in D.C., where they hope, in my view, to try to rig the outcome by getting a friendly judge. I mean, you may have seen in the news this week that this, I guess it was called the praying grandmother, the J6 praying grandmother, who went into the Capitol for allegedly 10 minutes, was just convicted by a D.C. jury of 4 misdemeanors. I don't know how much time she's facing in jail at the federal level. I mean to kind of say the detail how they're to describe that a grandmother or a great-grandmother is being charged with 4 misdemeanors in federal court kind of is to condemn it, right? But that's what's happening here in D.C. No wonder they want to get here. So I encourage you to read up on our case. There's a lot of detail in the Ashli Babbitt lawsuit that you would not have heard anywhere else, like the allegation that Lieutenant Byrd put out a false police radio call, that shots were fired, suggesting he was under fire when he was the only person who fired his weapon. And other problems with the way Byrd has behaved previously, both as a police, in terms of the handling of his gun and shooting it in unusual circumstances before. And again, this is a congressional police officer, the Capitol Police. I'd like to know where Congress is on all this. I'm not quite sure how it works legally, right? We sued the U.S. government over that congressional employee. It's a federal employee in the end. I'd like to know where what the Speaker thinks of all this. Does he have any influence in the outcome of this case? I don't know. I mean, Schumer runs the Senate, but the House is run by Speaker Johnson. Be interesting to see how it's going to turn out. So, we want justice for Ashli, and if you support this work, I encourage you to support Judicial Watch. Go to our website at judicialwatch.org, make a donation. This is the type of work we're doing. We can't do this heavy lifting without your support. And it's because of your support, or the support of many other folks like you, that we've been able to get this far as it is. So I want to thank those of you who have allowed us to do this great work to date, and I encourage you to continue that support, but also those of you who haven't supported us. I tell you, I think this Ashli Babbitt lawsuit is a pretty good reason to support Judicial Watch. I got more reasons, too. We've got an interesting case regarding Tucker Carlson. And we just sued under FOIA the State Department for records about Tucker. And I described it briefly here in this quick video.
Hey everyone, is the Biden State Department messing with Tucker Carlson? Well, Judicial Watch just filed a federal FOIA lawsuit to find out. We had asked the State Department for records about Tucker earlier this year, and they've done nothing but stonewall, citing unusual circumstances to hide records from us. Well, obviously that's not lawful. That's why we're in federal court now. Now, Tucker has alleged, for instance, that the Biden administration was trying to mess with his efforts to interview Vladimir Putin. That interview took place earlier this year. We want to know why the State Department is willing to break FOIA law to hide records potentially about Tucker Carlson. And hopefully we'll find out through our new federal FOIA lawsuit.
So why is the State Department citing unusual circumstances? Well, that's unusual, right? And my understanding of unusual circumstances based on my experience is, oh, this has political ramifications. We don't want to give you the documents as we're supposed to under law. We filed the lawsuit against the State Department for all emails and diplomatic notes from the Secretary of State, Anthony Blinken, his deputy, Victoria Nuland, and other top department officials that reference the former Fox News host. And you can see the list of top officials. So we weren't asking for everyone's emails there. We wanted to know what the top leadership were saying about Tucker. And we asked for it in February. And I don't think, as I recall from the lawsuit, I mean, we weren't saying give us everything that you said for all time. I think it was only since the beginning of the year. So it was a very small subset of individuals we were asking records from, but also very limited time frame. So this is a pretty easy FOIA request, right? And so their first response was unusual circumstances, and then it was radio silence. And that's why we went to federal court to get access to this information. Now, Tucker's been in the news recently because he published an interview. He went to Moscow and had an interview with Vladimir Putin that was run on X, or Twitter, what many people know as Twitter. And it got a lot of attention. It was the first interview that Putin had been granted to a Western journalist since Russia invaded Ukraine. So it was a very interesting video for a lot of people, including United States government officials. Now, Tucker had alleged previously that the Biden administration was spying on him. The NSA was spying on him. He said he had it confirmed. Tucker was also otherwise saying that they were trying to interfere with his efforts to interview Putin, unsuccessfully so. Now, certainly the fact that the State Department has said that, quote, unusual circumstances delayed the processing of the request suggests that Tucker is onto something. But what are they hiding? This is what I ask. Why is the Biden State Department violating FOIA law to hide records on Tucker Carlson? Simple question. Simple lawsuit, simple question. Maybe you have no records. Maybe they didn't talk about Tucker's interview with Putin. But you know that's not the case. They've got something, right? So we'll see what we get. Again, this is why I love Judicial Watch, right? Because we are able to ask these questions. There's this public discussion of scandals and government abuses, and I can't tell you how often the media fails to follow up, or Congress fails to follow up, or maybe Congress asks a few questions and they really can't do anything about it because they can't sue, or they don't want to sue over it or pursue a subpoena over it. And it's Judicial Watch that comes to the rescue and and tries to get the information and is able to get the information. So we'll see what we get related to Tucker, and I'll be sure to give you updates as warranted. So be sure to tune back here often. What I also love about Judicial Watch, it's not just here in Washington, D.C. that we do this heavy lifting. We do work throughout the nation. We talk about the case we brought in California for Ashli Babbitt. We've got election integrity cases right now in Illinois and Mississippi. More are coming in that regard, by the way, and litigation all over the country related to the rights of teachers and parents, right? Including a teacher up in Massachusetts who, before she was hired, had posted critical comments of the race-based obsessions of the left, and they used that, in my view, as a pretext to retaliate against her and fire her for that. And we lost at the lower court level because, you know, the law kind of makes it difficult to overcome the ability of school districts to sue teachers. I mean, to fire teachers for speech, because the standard typically is, now this is my understanding of it, so it may not be a perfect legal description of the issue, is that they have a lot of discretion. They think that's going to interfere with the school operations and the ability of the teacher to teach, they can get rid of the teacher. And we're saying all of that was really, all those arguments were not made in good faith, and they just targeted her because she said conservative things. So we had an oral argument on appeal before the First Circuit, which is the Circuit Court of Appeal at the federal level that handles cases for Massachusetts. She was fired, as we say, in retaliation for posts on social media that predated her employment at the high school that she was working at, Hanover. McRae was hired, by the way, the teacher's name is, I don't want to get it wrong because she's our client, Carrie McRae. Now, Carrie was hired as a high school teacher on August 31st, 2021, but she was fired over several TikTok posts that were made months prior to her hiring at the school. I think she was running for like a school board position, so some of that may have been campaign related. McRae, who was in May 21, she was elected in May of 2021, was elected to the Byrne School Committee, B-O-U-R-N-E, and she made the post in her personal capacity as a citizen and candidate for public office. McRae posted a TikTok video which stated in part, now, I've been banned from TikTok, by the way, so I can't go to TikTok and look at the video. Maybe I can, but I've been banned from TikTok. And our client got fired for posting a TikTok video, so be warned. So pretty much the reason I ran for school board, and that the reason I'm taking on this responsibility, is to ensure that students at least in our town, are not being taught critical race theory, that they're not being taught that the country was built on racism, so they're not being taught that they can choose whether or not they want to be a girl or a boy. It's one thing to include, it's one thing to be inclusive, and it's one thing to educate everybody about everything, but it's completely another thing to push your agenda, and with me on the school board, that wouldn't happen in our town. Does that sound like a big deal to you? Sounds to me like a straightforward, modest, moderate criticism of the left's agenda. And as we argue in our brief, I think at the appellate level, Hanover Public Schools fired McRae because of political speech she posted online months before she even became employed at the high school. In addition, the speech did not concern Hanover Public Schools. Completely unrelated. As she did not live in Hanover and was campaigning for a school committee position in a district 45 minutes away. I forgot about that. When we're working on these cases and our lawyers are working on the cases, I see these details in the pleadings and in our press statements and such. And then, this was 2 years ago, and the case, we went through discovery. But then I kind of go back through in our press releases when we have developments, and I'm like, boy, that reminds me, this was so outrageous. So I'm kind of like you. I get outraged again when I'm reminded of things, even within Judicial Watch, right? I mean, I'm outraged all the time, but then I'm reminded of things we've already uncovered, especially with our clients, and I get really mad. Nor did any student, parent, or teacher at Hanover Public Schools raise issues about our client continuing to teach at the high school. The school's sole excuse for firing her was that the school administrators believed that if she continued teaching at the high school, her unrelated pre-employment speech would cause a disruption. So it wasn't like it had caused a disruption. They were worried it might. Boy, that's a loophole they can drive a truck through to smash the First Amendment rights of public school teachers, even as constrained in the way I've discussed. The district court found in favor, this is the lower court, of the school district. It concluded the Hanover Public Schools' prediction of disruption was reasonable. McRae's challenging the ruling on 4 grounds. First, the First Amendment employment retaliation standard does not apply to unrelated pre-employment speech. Second, a mere prediction of disruption is insufficient to outweigh an employee's interest in engaging in political speech. Third, the reasonableness of that prediction is a question for a jury and is not appropriate for summary judgment. So what does that mean? It meant let the jury decide. The judge shouldn't just make a ruling outright that it's reasonable as a matter of law. Fourth, the district court incorrectly found that the Hanover Public Schools' prediction of disruption was reasonable. The district court's ruling should be reversed and the case should be remanded. So we have audio of the hearing. I don't think we have anything set to play, but you can listen to it. We'll provide a link to the hearing audio. And I don't know how it's going to turn out. As I said, this is going to be a tough nut to crack. But maybe the judges will agree with us. The appellate judges will agree with us and we'll win. So let's pray for that. We already had settled a civil rights lawsuit on behalf of another Massachusetts school teacher and parent, David Flynn, who was removed from his position as head football coach after exercising his right as a parent citizen to raise concerns about critical race theory. So, you know, critical race theory and DEI or woke theories are still being taught in our schools. Parents need to be able to speak out against it without fear of retaliation. And certainly school teachers should be able to talk about these issues that are in the public sphere without fear of getting fired. Don't you agree? But we'll see what happens. It's interesting because now there are a bunch of left-wing teachers who have been fired over comments they made as it relates to the Israeli conflict with the terrorists in Hamas. So you've had these pro-Hamas teachers getting fired. And they're kind of making these same arguments. Are they going to get vindicated? And if so, will that apply to folks like McRae? It's going to be very interesting to see how that plays out. So once again, I'll let you know how it plays out. So stay tuned to hear. Keep on coming back to our weekly update. And as you can see, we keep on doing the heavy lifting on topic after topic, on issue after issue, on issues core to our republic, core to the freedom of our citizenry to elect the president of their choice without being impeded by corrupt prosecutors and partisan biased judges. I tell you, Judicial Watch is second to none in defending your civil rights, your right to know, and holding corrupt government officials accountable to the rule of law. And we do it again with your support. And I encourage you to continue your support. And if you're not already, please go to judicialwatch.org and support our work. And with that, I will see you next time here on the Judicial Watch Weekly Update. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.